A.B. Dicey was a Whig jurist who came up with the concept of rule of law. Now there are three postulations of rule of law. अगर आप इन तीन postulations को देखोगे, कई बार हम इसको corollaries भी बोल देते हैं. Rule of law has three corollaries, and if you see, equality before the law flows out of the second corollary of rule of law. What are these three corollaries? Look here very carefully. First corollary says no man should be punished or made to suffer in body or in goods without the authority of law. It means you cannot punish a person without a law. It means every executive action must have legal justification. Got it? Second says what? That all the people are amenable. Amenable means they are under the effect of, amenable to ordinary laws and subjected to the jurisdiction of ordinary courts. Suppose there are two people, A and B, both of them commit murder. They both will be tried under the same murder law, or will there be different murder laws for them? Same murder law. And both will be adjudicated by the same set of courts headed by the Supreme Court of India. So equality before the law यही कहता है. जब equality before the law नहीं था, राजा के लिए अलग कोर्ट था, दूसरों के लिए अलग कोर्ट था, राजा के लिए अलग लॉ था, दूसरों के लिए अलग लॉ था. And the third corollary says that the constitution is the result of individual rights and it is the ordinary law of the land. But if you see in India's case, the constitution is not the result of individual rights, rather the constitution created the individual rights in the form of part 3 of the constitution, because British history is a history of contest against the king, and that's how the Magna Carta was signed, whereas Indian history is a history of protest not only against a king but also a legislature, the British legislature. That's why we have fundamental rights. Our rights are equally binding on the legislature as well as the executive. Americans also more or less have the same history, and that's why the same trajectory. Our constitution is not the result of individual rights, rather our individual rights flow from the constitution. And is our constitution an ordinary law? It's an extraordinary law. It enjoys special legal sanctity. Because Britain में तो आपको पता है parliamentary supremacy है, तो ordinary law हो या constitution, वो दोनों ही parliament बनाती. And that's why you see there is no difference between constitutional law or ordinary law. Therefore, constitution can be called as an ordinary law because it's similar to ordinary law. If A is equals to B, B is equals to C, A is equals to C. समझ में आया? This is made by the parliament, and whatever is made by the parliament is ordinary law. Therefore, constitutional law is equals to ordinary law. In India, is that the case? No. So the third corollary does not have any impact on India.